Hello, my name is Curtis Kennard. Heather Olson and I are the correctional ed leads for the United States Department of Education, Office of Special Education Programs, Division of Monitoring and State Improvement Planning. We welcome you to the IDA, General Supervision, and ensure the provision of a free, appropriate public education for youth in adult jails presentation. Now we will talk about the OSEP disclaimer. The contents of this presentation were developed by the presenters for the 2022 OSEP conference. However, these contents do not necessarily represent the policy of the Department of Education, and you should not assume endorsement by the federal government. On the next slide, you have the moderators and presenters. You have the Michigan Department of Education, Pennsylvania Department of Education, and the United States Department of Justice. This presentation will show the collaboration between the Office of Special Education, United States Department of Justice, the Michigan Department of Education, and the Pennsylvania Department of Education. Michigan will discuss how it became aware of a statewide problem involving youth with IEPs held in county jails and the action taken to address the problem. And Pennsylvania will discuss its process for ensuring juvenile incarcerated receive a free, appropriate public education, as well as for monitoring compliance with Individuals with Disability Act. The United States Department of Justice will explain why requirements under IDA do not go away during a pandemic, and why youth with disability in juvenile and adult facilities are entitled to receive special education and related services. On the next slide, we have IDA. Let's take a moment to briefly cover one point of IDA. As you know, the Individuals with Disability Act is a law that makes available a free, appropriate public education known as FAPE to eligible children with disability throughout the nation, and ensures that special education and related services are provided. One purpose of IDA is to assist states, localities, educational service agencies, and federal agencies to provide the education of all children with disabilities. Now, during the pandemic, OSEP developed several question and answer documents. One of those documents is Part B, Procedure Safeguards in the COVID-19 environment. As you can see in bullet 1, this document basis states the special education and related services are to be provided no matter what primary instructional development approach is chosen by the state or the LEA. On bullet 2, it basically says states and local decisions require schools to limit or not provide any service instruction due to health and safety concerns, meaning that the SEA, the LEA, and the IEP team are not released from their obligations to provide faith to each child with a disability under IDA. Further information can be found in the links on the slide. Now I will be followed by Michigan Department of Education.
Okay, thank you. Hi, I'm Rebecca McIntyre, Interim Assistant Director for the Michigan Department of Education, Office of Special Education. I'm going to share a little about the journey the Michigan Department of Education, Office of Special Education engaged in with our districts, intermediate school districts, county jail administrators, and sheriff's departments. In November of 2019, 4 state complaints were filed against different intermediate school districts, alleging child fine violations and failure to provide services to youth with disabilities who are held in county jails. Subsequently, 5 more state complaints were filed upon issuance of the final decisions for the first 4 state complaints. State complaint investigations included Freedom of Information Act requests to obtain student information from jails, interviews that uncovered child fine did not include county jails, and services were not provided to youth held in county jails. And lastly, research was completed to identify applicable case law and/or state or federal guidance. The only known case law in Michigan was from 1991 and was specific to the Michigan Department of Corrections, which indicated the state's obligation was for individuals through 21 years of age due to the federal obligation. The final decisions were issued and found consistently that although intermediate school districts had general child fine policy and procedures, neither policy or procedures actually addressed jails. The final decisions also captured that intermediate school districts reported a lack of staff and/or a lack of system for identifying who needs special education services or which entity should provide the services. So this is where the journey started. I will walk you through some of the larger steps we took along the way, which included monthly updates, stakeholder meetings, development of statewide guidance specific to FAPE for youth with disabilities in county jails, as well as group and individual technical assistance to intermediate school districts in developing a system to ensure FAPE for youth with disabilities in the county jail that is located within each county. Where there was no system for special education in county jails, we had to assist in creating one. Rather than focus solely on the intermediate school districts that were the focus of the state complaints, we focused on supporting the state as a whole, initially through the lens of a diverse group of people with varying perspectives of their own regarding the provision of services to youth with disabilities that are held in county jails. The final guidance document that was released in August of 2020 can be found on the resources slide of this presentation. Now on the next slide, we'll talk about the purpose and introduction. So let's talk about Michigan. Where the IDEA is specific to children and students through 21, the IDEA also allows states to establish their own age limits. Michigan has an expanded age range of birth to 26, of which there are 211,000 children, students, and young adult learners with disabilities. There are 828 school districts across the state that are part of 56 intermediate school districts. On the jail side of things, there are 82 county jails that are located in the 56 intermediate school districts across the state. The work we engaged in focused solely on county jails and did not include city jails, Department of Corrections, or any other juvenile justice type facilities. There are no laws or rules in Michigan specific to county jails, and the provision of special education, county jails and the provision of special education. And we found pretty quickly that there was very minimal case law and guidance on this topic as well. In the next slide, we'll talk about MDE's commitment to ensure FAPE in county jails. So the MDE made a commitment to being involved with intermediate school districts over the long term in supporting system development and collaboration to ensure students with disabilities confined to county jails receive a FAPE. An internal team was formed to coordinate the work. Prior to state level work group being assembled, there were several meetings taking place on this topic internally. Much of the time to this point was spent on research, looking at legal requirements, the history of educational services being provided in county jails, and previous state complaints. When the internal team reached out to intermediate school district directors in the state who had been working on their educational programs in the county jails, in addition to MDE Title I staff and the Office of Adult Education, which in Michigan is housed in a completely different agency called the Labor and Economic Opportunity Workforce Development. Both Title I and the Office of Adult Education had some involvement in educational programs in county jails across the state. And we met to discuss their knowledge of these educational programs and to share information about the questions and the state complaints we were receiving. After forming the statewide work group, which, by the way, was started just prior to the pandemic, so everything was done virtually, which actually allowed for broader participation from across our state. We met several times, and it became clear that the work would move forward with a shared student-centered perspective, not intermediate school district perspective or county jail focused. Just want to share a couple of quotes before moving on. So from a jail administrator involved with our stakeholder group, he said, approach the jail administrators with partnership thinking. Explain the value to the correctional institution. Understand that the primary responsibility of the jail is confinement, but secondary is education. We want people to be successful and not return to jail. From the FAPE and the county jail guidance document, we have a quote that says, student-centered outcomes provide a catalyst for the development of a strong collaborative partnership between the intermediate school district and the county jail, while maintaining the purpose and integrity of each. So I also want to share a line with you specific to perspectives, again, out of MDE document, FAPE in the county jail. A student's confinement is an opportunity for intermediate school districts to engage in rich collaboration with county jails to impact the trajectory of a student's life. This constant never changed throughout our work. The requirement that students with disabilities placed in county jails are entitled to a FAPE allowed people to work collaboratively and gave them the space to share perspectives, work through questions, and think differently about how to best serve students, all while keeping in mind the unique structure of jails and the various people who would need to be involved in order to be successful. Through this work, we had to reconcile the different purpose of each system while trying to interconnect the two systems being educational and correctional jails. Early in the process, there was a shared perspective among some intermediate school districts that jails were not willing to engage with intermediate school districts and district staff, that when approached, the jail administration would deny educational personnel access to students in jails. Many early questions and concerns from the intermediate school districts focused on the jail's responsibility for students with disabilities and how rules and regulations applied directly to the county jails. Some jail administrators thought the intermediate school districts would expect the jail to become an education provider. It was our work at the State Department to recognize, share, and provide an opportunity for intermediate school districts and jail administrators to discuss these assumptions, develop relationships with each other, and build systems. So 2 last quotes before we go to the next slide. One of the biggest roadblocks to relationships building is assumptions. The jail might be picturing one thing, the school district another thing. Dispelling those assumptions is key. That came from one of our jail administrators. Another quote, relationships and your ability to build and sustain relationships is your key to success. Figure out who to connect with. Most jails want to do the right thing. You'll find your champions within the system. another jail administrator. So let's talk about establishing the authority of the ISD. The role of the MDE in this work served as a conduit in the following ways. We provided a space and opportunity for various stakeholders to meet in an organized format. We provided an open line of communication for people to ask questions. And we maintained ongoing communication with intermediate school district directors and jail administration staff. Because we are continuing to communicate with intermediate school districts and local school districts, we are able to keep our hand on the pulse of what's happening between the intermediate school districts and the jails. We know our intermediate school districts are at different stages in this work. Some have long established systems and relationships with the jails. Some are strengthening relationships, and some are in the very early stages of the system building process. One issue that intermediate school districts have shared with us as they implement their system in the county jails concerns statewide data. These concerns include questions such as, how do I access information for a student who comes from a different county? Has a student been determined eligible in the past? Which district has the student's IEP? So in our role at MDE, we are identifying new stakeholders for these questions. For example, our State Center for Educational Performance and Information, and doing some research and exploring solutions to this data issue. Another big part of our role is to remind our intermediate school districts about their role and responsibility to students with disabilities in the state of Michigan until they are 26 years old. The guidance document we developed includes citations from Federal Individuals with Disabilities Education Act, the state statute in Michigan, which is the Michigan compiled law, and the Michigan Administrative Rules for Special Education, which is our state rules. And they all establish the authority of the intermediate school district. We did not develop one system at the State Department level and impose it on all intermediate school districts. The document we developed gives ISDs the permission, adaptability, and flexibility to create a local system in partnership with their jails. And that partnership will meet the unique needs of their systems and their communities. So on the next slide, we'll talk about next steps and resources. So as we move forward with this work, honoring our commitment for the long term, we continue to seek feedback from intermediate school districts through surveys and meetings, and we provide dedicated support to ISDs and local districts. The original MDE core team remains assigned to the work, and for consistency, fields the questions regarding special education in county jails as we receive them at the department. Michigan has created presentations for national and state venues, and we are currently exploring opportunities to work more closely with our county jail administration colleagues and their state associations. We have updated our state child fine guidance to include an expanded section on child fine for adult learners, including students who are confined to county jails. The jail's work prompted questions about adult learners with disabilities in general, and not just those in jails, and overall how FAPE is being provided to them. We are currently in the process of developing another guidance document titled FAPE for Adult Learners. Lastly, since students with disabilities held in county jails are part of each state's general supervision system, the MDE will develop monitoring activities to ensure the provision of special education and services and the obligation to conduct child fine for youth with disabilities in county jails. And with that, I will turn it over to Roni at Pennsylvania.
Hello, my name is Roni Russell, and I am an educational consultant with the Pennsylvania Training and Technical Assistance Network through the Pennsylvania Department of Education. We are the training arm of the Bureau of Special Education. Today, I'm going to talk to you about what Pennsylvania has done in regards to ensuring that FAPE is provided to students in county prisons and jails. As you see on this slide, this is the federal requirement under 34 CFR section 300.600 for state monitoring and enforcement, which requires us to do cyclical monitoring. So let's look at the next slide in regards to what Pennsylvania has created, which are called basic education circulars. These are not law, however, they take our laws and regulations and put them into guidance. So you see that the basic education circulars and the policy guidance in the first link can be found at the Department of Education website. On that website, under those basic education circulars, you find first and foremost our basic education circular on education services for students that are incarcerated. There is also one on non-resident students in institutions. And there is also one in regards to educational programs for students in non-educational placements. For today's purpose, we're going to talk mostly about education services for students that are incarcerated, the 24 PS 1306.2. In regards to this, after Pennsylvania back in 1997 timeframe was audited and found that some students sat in county jails and county prisons, we were tasked with going into our 65 county prisons within 2 years to ensure that there was the provision of FAPE and that there was a link between the county jail, be it the warden or the education director, and the local education agency linked to that county prison or county jail. In this provision of 1306.2, just want to read you some excerpts that come from that BEC, but please do take a look at it as you look through these resources. So school districts, after this lawsuit occurred and we went into those county prisons within 2 years, they were told to, and going forward, to comply with the child fine obligations of IDEA, to utilize appropriate evaluation procedures and diagnostic screening instruments to determine the eligibility and educational needs of inmates, to implement timely review and or develop individual education programs, IEPs, for eligible students in accordance with state and federal laws, and to provide FAPE in conformity with the student's IEP. So section 1309 of our school code permits the district providing special education to charge the district of residence from where the student originally came as a special education student charge and not to exceed the total net cost of the special education program provided. Again, this transfer of funds from the school district of residence to the school district in which the local correctional institution, county jail, or prison is located may include that deduction of the appropriate amount from their basic education funding allocation. Again, this is all written out in this 1306.2 PEC. Additionally, I think it's important to note that part of this responsibility is to provide annual public notice under section 14.121, where school districts or the local education agency, the host school district, should send their annual public notice to the warden of each county jail or prison within their jurisdiction. Furthermore, districts in each local correctional institution are located must develop a systematic, ongoing means of communication. And this is really key to these ongoing efforts to make sure that we are providing FAPE to our students. So this ongoing means of communicating with these institutions to ensure that all students that are incarcerated who may be eligible for special education are located, identified, evaluated, and when deemed eligible, offered a free appropriate public education. In addition, districts may obtain information from our department's Penn data or the Pennsylvania Information Management System database to determine whether school-age inmates have previously been identified as eligible. Additionally, and we're going to talk about this on another slide, they can also contact our records center to help with retrieval of records. So on the next slide, we're going to talk about how we formed a team and what we do going forward. So we have a team that's called the Regional Assessment Support Team. In 1984-85, the Corrections Education Division initiated a formal special education programs and services in the state-operated adult and juvenile facilities. The introduction of the RAST projects in 1986 actually enabled a system-wide implementation and delivery of special education programs and services. And to this date, we do continue that oversight and continue cyclical monitoring. Let's now look at other goals of our team. So some goals of our team are to cyclical monitor the provision of special education services to publicly placed Pennsylvania students in state juvenile, adult correctional, county prisons, county detention, private rehabilitative residential institutes, partial hospitals, and residential facilities. We also assist staff in state juvenile, adult correctional facilities, county prisons, county detention centers, private rehabilitative residential institutes, partial hospitals, residential facilities to implement state and federal special education regulations and provide technical assistance to those staff. Of note for Pennsylvania specifically is that we cyclical monitor every state juvenile and state correctional institution every 3 years. The reason that we do this is because they are not, they are their own local education agency. And this Pennsylvania Department of Education used to have the oversight of education in our state correctional institutions. But in 1999, Act 15 of 1999 moved that oversight from the Department of Education to the Department of Corrections. So in our state correctional institutions that are not Commonwealth diploma granting institutes, meaning that they do not give high school diplomas to our students 21 and under, and hopefully are not taking our students with special needs, they're going to other institutions that have certified teachers. They are monitored every 6 years just to ensure that they understand child find and the process if they would happen to get a student with an IEP. So another goal of our team, as you see here, is to assist in state juvenile and adult correctional facilities with student assessments for potential and identified eligible students. We also, as I noted earlier, support a record center to assist with retrieval of student educational records. We also coordinate facility level procedures for collection of PEN data and our Pennsylvania Information Management System, which is our child tracking system. We also help to coordinate the provision of related services, such as if a student comes in with an IEP and needs speech services, we would help the institution get the speech therapist to their institution to do either an evaluation or continuous related service provision for that student. Another example, which has been noted prior, is that we also help folks to get surrogate parents, or at least locate through their local intermediate unit in Pennsylvania if a student needs a surrogate parent. And those, again, are just two examples, not to cover all of the related services that we could. And then we also provide special education curriculum resources and support. So again, let's look further at other goals of our team. We also support special education and related staff in each juvenile and adult facility in reviewing assessments and improvement for renewal of programs to deliver identified exit outcomes for our students. We provide support as appropriate for student transition to and from correctional centers. Our current team consists of special education consultants, which also are our cyclical monitors, to include myself, a school psychologist, the Pennsylvania Department of Education Bureau of Special Education liaison, record center staff, and then we also have the Pennsylvania Department of Education Student Services liaison, which is our liaison that's requested when students are graduating, and the information gets sent to this person to service those diplomas and or GEDs disbursement. And we also, which is really key, is have a program manager from the Pennsylvania Department of Corrections Education that is part of our team to talk about ongoing needs for our students, our teachers, administrators, and what training that we can provide to them. So let's look further at our data and resources for Pennsylvania on the next slide. So Pennsylvania has 6 state correctional institutions that we call Commonwealth Secondary Diploma Granting Institutions, meaning that they have certified teachers, certified principals, that if it all goes right, most of our students with special needs go to these institutions in the state of Pennsylvania. Amongst that, we also have 18 state correctional institutions that are Commonwealth diploma granting institutions. And again, as I noted earlier, we also monitor them just in case they would get a student that would have an IEP and they would know how to conduct that child find process. We also have now 5 state juvenile facilities. And as I mentioned, we have 65 county prisons. We actually have 67 counties in Pennsylvania. However, 2 of those are smaller jails, if you will, not really a big jail like the other 65. And then we also have county detention centers in Pennsylvania that we oversee. And again, I can't emphasize enough that as per the Code of Federal Regulations, our Bureau of Special Education must conduct state monitoring and enforcement. And this is based on the outcome of cyclical monitoring. We provide, through the Bureau of Special Education, this technical assistance to assist with non-compliant situations that these facilities may have. And again, we monitor our state institutions on a 3-year basis, and our county prisons and county detention facilities are monitored every 6 years when the host school district is also monitored where those facilities sit. So now let's look at our ongoing efforts that we continue to do with our RAST Regional Assessment Support Team. So we continue to meet with state level folks from the Department of Human Services, and we do this to review monitoring throughout the year and outcomes, just to make sure that we're not missing something amongst different agencies in regards to the provision of FAPE to our students with IEPs. Additionally, we provide professional development. Pennsylvania has a Department of Corrections Training Academy that we're often invited to provide training to staff and administrators, regular education and special education teachers. We also, and just conducted this, we provide professional development at the Corrections Education Association Conference. We try to always submit a proposal to present there, and we also provide ongoing technical assistance as is needed. With our Pennsylvania Training and Technical Assistance Network, which all of those services are free to all of our school districts and entities in Pennsylvania. We provide technical assistance and training, and all of our teachers and administrators in correctional facilities are available to attend those trainings. And again, we also provide specific trainings to them. So again, these are our ongoing efforts, and please take a look at the resources either at the Pennsylvania Department of Education, basic education circulars for our legal guidance. And also please take a look at the Pennsylvania Training and Technical Assistance Network under partners to see the information about our Corrections Education Division. Thank you. And now I'll turn it over to Ryan.
Thank you so much, Ronnie. I appreciate it. My name is Ryan Wilson. I'm a trial attorney in the United States Department of Justice Civil Rights Division Special Litigation Section. Today, I will be discussing the law around the responsibility of local and state educational agencies to ensure that young people in facilities who may be eligible for special education and related services receive those services. I will explain the IDEA law, and I will provide an example from a case where our office took a position on the responsibility of agencies to provide services to children in correctional facilities. Let's discuss one issue that school districts and correctional facilities struggle with, and that is whether young people with disabilities in adult prisons and jails are entitled to special education services. These young people are often 18 to 21 years old, charged as adults, but according to the IDEA, are still eligible for special education and related services. The IDEA is clear that the requirement to provide a free, appropriate public education extends to children in juvenile and adult correctional facilities. This requirement also continues during the pandemic. Even during the pandemic, agencies must ensure that they are providing special education and related services to the greatest extent possible. So who's responsible for providing special education to young people in adult facilities? The IDEA places that responsibility on all agencies within a state that are involved in the education of children. So that includes state educational agencies, local educational agencies, and state and local juvenile and adult correctional facilities. This is a joint responsibility. The IDEA does not exempt one public agency from its duty to provide special education and related services because another public agency shares that duty. Many educational agencies will develop agreements between the state and local educational agency and the correctional facility to describe the duties that each agency has to provide special education and related services. On the next slide, we'll talk about four narrow exceptions to the requirement that children in adult prisons and jails have access to the services in the IDEA. First, if the young person is between 18 and 21 years old, and the young person has not previously received special education services or previously been identified as a child with a disability and does not have an IEP, there is no requirement to provide special education or related services. Second, public agencies do not have to include children with disabilities in state and district-wide assessments if the young person was convicted as an adult under state law and the young person is incarcerated in an adult prison. Third, public agencies do not have to provide transition services if the young person was convicted as an adult under state law, incarcerated in an adult prison, and will age out of services before they are eligible to be released. Finally, if there is a genuine and compelling security interest that cannot be accommodated, public agencies can modify the services in a young person's IEP or the placement where the young person will receive those services. The next slide shows an example of our advocacy on this topic. In 2018, DOJ filed a statement of interest in a case involving the Palm Beach County School Board and the Palm Beach County Sheriff's Office regarding who was responsible for providing special education and related services to young people with disabilities charged as adults, detained in the Palm Beach County Jail, and placed in solitary confinement. The Sheriff's Office argued that it had no responsibility to provide special education services, and the school board argued that it had no responsibility to provide special education services to youth placed in solitary confinement. In our statement of interest, we affirmed the IDEA law requiring all agencies involved in the education of children to provide special education and related services to eligible children. Public agencies cannot avoid their IDEA obligations by allowing another entity to interfere with carrying out its responsibilities. Thank you. I will turn it over to Heather Olson, who will conclude our presentation.
Thank you, Ryan. On the next slide, as you think about the information which has been presented, consider your responses to these questions. Can you describe what the provision of FAPE looks like in your state for youth with IEPs that are held in county jails? How is your state ensuring whether youth with IEPs are being provided FAPE while held in county jails? To help you begin your own journey with IDEA, general supervision, and ensuring the provision of a free and appropriate public education, FAPE, for youth in adult jails, we want to share some resources and ideas with you. If you look, we will be talking about federal, state, and local resources. Next slide, please. The Monitoring and State Improvement Planning Division within OSEP is responsible for the formula grants. We have multiple resources which will help clarify several questions regarding children who are incarcerated, with disabilities who are incarcerated. You'll find this helpful as you begin planning. We have several methods of ensuring services, and these are described on the next slide. And it provides an overview of the different methods which are used to ensure services are delivered to students with receiving special education who are incarcerated. Also within OSEP, we have a research to practice division. They have resources which discuss evidence-based practices regarding correctional education, including professional development models at the IRIS Center, which are specifically designed for educational staff in correctional facilities. Research to practice also includes resources for parents, and the websites on this slide can provide support and information to help parents and caregivers support their child who may be incarcerated. Rehabilitation Services Administration provides leadership and financial resources to assist state and other agencies to provide vocational rehabilitation and other services to individuals with disabilities. Direct contact information is available on this slide. The Office of Career, Technical, and Adult Education offers resources to assist jurisdictions with young adult diversion programs. This office also offers tools and resources to help stakeholders design career and technical education programs to improve community reentry outcomes. Title I Part D offers supports and services for children and youth in local, tribal, and state institutions who are neglected or delinquent children, so that they have the opportunity to meet the same challenging academic standards. People can contact them directly for more information about their program and resources as well. Further information about Title I Part D can also be found on this slide, and the links offer information regarding specific programs. McKinney-Vento for homeless children and the Youth and American Rescue Plan are additional available resources which can help with the development and implementation of correctional education programs. Here is the contact information for the National Center for Homeless Education. The National Technical Assistance Center on Transition, the collaborative, provides information, tools, and supports to assist multiple stakeholders in delivering effective services and instruction for secondary students and out-of-school youth with disabilities. Information and technical assistance can be found at the National Evaluation and Technical Assistance Center for the Education of Children and Youth who are neglected, delinquent, or at risk as well. And contact information can be found on this slide. The Coalition for Juvenile Justice, the CJJ, is a nationwide coalition of state advisory groups and allies dedicated to preventing children and youth from becoming involved in the courts and upholding the highest standard of care when youth are charged with wrongdoing and enter the justice system. They share what works with restorative practices, and further information can be found on their website. The contact information for OSEP's Correctional Education State Leads is on this slide. And we may be contacted directly with questions, concerns regarding correctional education. Finally, thank you for attending our session. It's important and crucial that we all work together to support our students in having the best possible educational outcomes while they are incarcerated. Thank you.